Welcome to Just Liberty, where justice and liberty meet. I'm Alan Reinach, Executive Director of the Church State Council, and I'm here with my co-host, Bettina Krause, editor of Liberty Magazine. Together, we're trying to recover religious liberty from the political extremes. And Bettina, what are we going to talk about first today?
We're talking today about former Associate Justice of the Supreme Court, Sandra Day O'Connor, one of my personal heroes, not least because she was the first female justice on the court. She died at 93 years old, a venerable member of the judiciary with a lot of decisions under her belt. And many of them were memorable because of the position that she occupied as sort of this swing vote on the court. And so she was able to push jurisprudence to one side or the other in quite a few cases, including religious liberty cases, right?
Right.
I mean, Alan, what do you see as her key legacy in this area?
Well, she's also very central to my own professional life, Bettina, because when I showed up at law school at the University of North Carolina in 1983, she was fairly new on the court. And after in the spring of my first year of law school, my criminal law professor asked me if I would clerk for him that summer. He was working on an article, a law review article, analyzing Justice O'Connor's decision in Wallace v. Jaffrey, one of her first decisions, and her approach to the First Amendment religious freedom clauses. And so I got the opportunity to get, minimum wage, as it were, to read all of the cases, read all of the law review articles, and butt heads with a guy who was number one in his class at Yale Law School, and who could run rings around me intellectually and, was obviously much more experienced. And discuss her contribution, which was, at the time, there was a prominent test of separation of church and state that government had to act and pass laws that were primarily for secular, not religious reasons. You couldn't just act for a religious reason, religious purpose, or for a religious effect. Your primary purpose and effect had to be religious, and it could not unduly entangle church and state. And that test, known as the Lemon test from the case Lemon against Kurtzman, had come under attack. But O'Connor's insight was, really what this is all about is that government, should stay out of the business of religion, shouldn't be endorsing religion. It's called the endorsement test, right? And she was also central in dealing with the principle of non-coercion. So government shouldn't be taking sides and endorsing religion in general or a particular religious viewpoint or belief, and it shouldn't be coercing people to believe that. Now, both of those concepts that she had championed have been thrown out the window, or
Right.
the door, or the courtroom door.
The courtroom door. You're absolutely right, Alan, because that really was the genius of her approach to First Amendment issues. In the main, she supported strong church-state separation, although there were some instances where it wasn't so strong. But in the main, she supported strong church-state separation, while at the same time balancing that with a very expansive approach to religious free exercise. And that balance between the two clauses is the necessary balance for preserving religious freedom for religious minorities, people of no religious faith at all, as well as those who belong to mainstream religions.
And it's certainly true that the court has really moved away from her concepts of non-endorsement and non-coercion in ways that have really undermined our historic tradition of religious freedom.
And put the thumb on the scale in favor of expansive religious free exercise and diminished Establishment Clause protections.
Yes, in a way that enhances the ability to be publicly coercive in favor of one religion over others.
Well, Alan, I mean, this discussion about her legacy could continue on for some time, but I want to get to the interview for this episode, which I am really excited about. Are you ready to meet who our interviewee is?
I cannot guess who it might be.
So, Alan, I am delighted to introduce our guest for today, who is a familiar face and voice around these parts. It's you.
Yes, it is. I've never been interviewed on my own show.
There's a first time for everything, and people hear your title in the intro every episode. And you are executive director of the Church State Council. And we kind of breeze by that. But a very important anniversary is coming up this year, which is
The 60th anniversary
60th,
of the Church State Council.
anniversary of the Church State Council. So I wanted to take some time to help people understand what this organization is and what it does. And so maybe we can start from the beginning. I mean, where did this organization get its start and why did it come into existence?
1963, California introduces a Sunday closing bill on the heels of Supreme Court decisions saying that they were illegal. And the Adventist Church here in California, in the western region, sends a young attorney to Sacramento to oppose the bill. When he comes back, by the name of Warren Johns, who some longtime Adventists will recognize because he went on to become general counsel for the Adventist Church. Good friend and close colleague of our then president of the church, Neil Wilson. He comes back and the administrators decide to establish, we've had organized religious liberty ministry in the Adventist Church since about the late 1880s. In fact, in California is where the predecessor of your own publication, Liberty Magazine, began at Pacific Press then in Mountain View. Then it was in Oakland, California, back in the late 1880s, right? So we've had religious liberty emphasis and department for decades, better part of a century, but they wanted to organize a specific organization to really be involved in legislative work primarily. And at that time also, the Civil Rights Act had just passed, and there were going to be opportunities to enforce the new laws against religious discrimination in the workplace. And so Warren Johns became the first director of the Church State Council. He was succeeded a decade later by a church administrator, John Stevens, who served for 20 years. John promptly opened up a Sacramento office to cover legislative matters. And I came around in 1994. So I've been here for half of the organization's existence for a full 30 years. And I guess the way the Lord led me was to really develop the litigation side of things and to file the religious discrimination cases and really pursue that.
So, Alan, it fascinates me that Sunday closing laws was sort of the precipitating event, so to speak, for getting this organization off the ground. And then it sort of developed as a way to keep an eye on religious accommodation in the workplace and so on. But that focus on serving perhaps the religious freedom needs of Seventh-day Adventist Church members, that did not remain the focus of your organization for long, right? Or the exclusive focus of your organization.
Well, legislatively, it had always been religious freedom for all.
Right.
Okay. But when I started taking on cases, really, we were not known outside of the Adventist Church. So pretty much what we got were calls from pastors about church members who were being made to work on Sabbath, Sunday on Friday, Sunday on Saturday. As I got as I circulated within both the faith community and the legal community and the employment law community, and, did a lot of networking, and, I'm a kind of a friendly, social person. We started getting more referrals, getting better known. Legal conferences talking about religion would want somebody who was representing plaintiffs. I was the only one they could find, so I'd get speaking opportunities, and then I'd get better known. But I was taught, the staff I inherited were my mentors because they'd been doing it, even though I was supposed to be their boss. And I was taught we represent people of any faith. And so, when I talk to churches about what we do, and I ask them, should we just represent people of our own faith, or people of any faith? Always, the universal is yes, we defend religious freedom for everybody. This is kind of in the DNA of the Adventist people.
So give us a sense, Alan, of some of the cases you've taken on over the years and the people that you've represented.
One of the more kind of notable cases, because one of the Christian teachings that's very socially unpopular is teachings about creation, God as creator, and particularly challenging the sort of scientific geologic orthodoxy about the long age of the earth, right? So I had a client who was a lab tech at Cal State Northridge, and he had discovered on a search for dinosaur bones in, I want to say, Montana. He had discovered a bone that had soft tissue. Like skin is soft tissue, blood is soft tissue, right? And over millions and zillions of years, you wouldn't expect, soft tissue you would expect to decompose within a
Right.
matter of a few years, right? And he showed it to one of the grad students, who got very excited and went and blabbed about it to the department chair. And anyway, he wound up getting fired. And it was clearly a case of religious discrimination. He hadn't he hadn't been saying anything about God or religion or where. I mean, they knew he was a creationist, um, but that was the first and only time that anybody's won a case. We won a very nice settlement for him, that's really had a successful outcome for creationists, because the creation science cases always lose.
Can I say, Alan, that is quite a story. I've not heard that about that case before, but it really does show the diversity of issues that come up in the religious freedom arena, right?
Yeah, no, they're incredibly diverse, and people, when they start chatting with me, they're like, "Boy, you have some interesting cases." They're not all just straightforward, like Mr. Groff's case that went to the Supreme Court. Somebody who wouldn't work on Sunday and deliver Amazon packages for the post office because, for him, Sunday is the Lord's day.
So let's talk about that case, Alan, because number one, it's recent. And number two, it is, would you say, perhaps one of the more significant cases you've litigated in your career?
Oh, undoubtedly the most significant. And by the way, it's still going on. But, you know, I mean, for our whole career, we've been under the shadow of TWA against Hardison.
Explain this in detail for people who aren't familiar with the law.
1977, the Supreme Court decides the first case involving a newly revised statute that requires employers to accommodate religious beliefs and practices such as Sabbath observance. Sabbath was the motivating reason for the Civil Rights Act to be amended in 1972. And there was language in the court's decision that has been understood ever since as saying that employers are off the hook. They don't have to accommodate if to accommodate would produce even a kind of a bare minimum hardship. And so, based on that sort of dumbed down standard interpretation of the phrase undue hardship, it's been very, uphill battle. to get these accommodations and to win these cases over the years. Um, we've been trying to get that interpretation changed literally for decades, because following up on that, Congress enacted the Americans with Disabilities Act and also said you have to accommodate, but not if it's an undue hardship. But they defined undue hardship as a significant difficulty or expense. They didn't want to be stuck with, just bare minimum accommodations.
And so that lower standard that was applied to religious accommodation cases, that in practical outcome has led to quite a lot of suffering, right?
It has. It has. A lot of folks, I mean, the biggest problem is not the difficulty winning cases. The biggest problem is that they're cases in the first place, right? That people are getting fired. People are, working on Sabbath because they're not getting accommodated. They can't afford to lose their jobs, or they're losing their jobs. For every case that gets filed, there's probably 100 people who either succumbed to the pressure or lost their jobs and didn't have a case.
Right. And it's not just Sabbath accommodation, it's issues of dress and grooming, right?
Those are the two biggest categories historically have been, holiday observance, Sabbath observance, Sunday. I had a case back in New York where somebody lost his job. He was a member of the Brooklyn Tabernacle Choir,
Hmm.
and he had commitments to choir practice. That's a religious activity that deserves to be accommodated, right? World renowned, or certainly nationally renowned, gospel choir. Um, so it could be any number of things. There's still conflicts over wearing of beards, and of course, a bunch of cases involving Muslim women wearing the headscarf, the hijab.
Yeah. So that brings us to this case, Groff, Mr. Groff. How did that come to you and where did it end up?
Well, it came to me because I had been developed a national reputation and networked with all these different groups, and so it was Alliance Defending Freedom, a national network of Christian attorneys that I'm the guy that does the employment cases, the religious employment cases. So they called me when they got the call from a Christian rights group in Pennsylvania. And so they teamed me up with a very fine firm of a couple of younger Christian attorneys in Pennsylvania. And this was before Mr. Groff had even been written up the first time, but he knew he was in trouble. And so it was a long process of walking him through, protesting his write-ups and filing discrimination charges, et cetera, et cetera.
And what happened?
Well, eventually, he was on the eve of getting fired. He'd gone through all the progressive discipline. They brought him in for like 8 counselings, trying to get him to work on Sundays. He was about to get terminated, and he decided to submit his resignation, because if you're a federal employee, you have a termination on your record, you're never going to work for the federal government again. So after that, we went through the administrative proceedings, and then we filed the case right in court.
And to cut a long story short, what happened ultimately?
Well, the way you get to the Supreme Court, quite frankly, is by losing. So, maybe I'm some brilliant lawyer or whatever, but it was not an intentional strategy to get to the Supreme Court by losing. I will tell you that much. But we thought we had a winning case. By rights, we had a winning case. But we lost in the trial court, issued summary judgment, went up on appeal. The appellate decision was split, but it really set up the issue quite squarely for the Supreme Court. What is the standard of an undue hardship? Court said, based on the bare minimum standard, the post office wins. And we said, court, this is a perfect time to tell us that the standard is something more than bare minimum. And they agreed, and they did. And they said, yeah, the standard undue hardship doesn't mean bare minimum. It means not just a hardship, but a hardship that's unwarranted, that's undue. In light of all the size and the circumstances, it has to be unreasonable amount of cost or impact on the conduct of the business. It's got to be a significant hardship.
And that ruling was a culmination of 50 years of litigating and fighting and filing suit, not just your organization, but other religious freedom organizations trying to get that standard reviewed. And there you have it. We now have, to all intents and purposes, a new standard, right?
Absolutely. And it's making a huge difference already.
So as you look around, I mean, this is an anniversary time. You're reflecting on what your organization has achieved, which is significant. But as you're looking around, what is left for your organization to engage with? What is left for you yet to do? What do you see as the biggest challenges ahead?
Well, in terms of shaping, I'm going to answer that in terms of shaping the law. Okay. In terms of shaping the law, there are a couple of other things that we're working on. One has to do with how companies interview job applicants. The law says you can't ask open-ended questions about schedule and not tell applicants not to disclose their need for a scheduling accommodation, whether it's disability or religion, but they do it anyway. So, this is a big issue, and we've been fighting these failure to hire cases when they find out somebody doesn't work on Saturday. And, so we're fighting those. The other thing has really come to the daylight, frankly, in the explosion of the COVID accommodation cases, because there are, tens of thousands of Americans lost their jobs because they determined to trust God rather than what the government was telling them about the vaccine. Now, our church is pro-vaccine. I got the vaccine. I don't have a problem with it, but I can't fault somebody for saying, this is a new vaccine. It's under an experimental approval. I don't really know very much about it. I'm going to trust God. God's promised to take care of me. And, he's not going to let me go until it's my time, whatever. If people have faith and they want to exercise faith, that ought to be their religious freedom. But in the context of this, there was an awful lot of arm twisting, which in legal terms is called harassment, right? That if you tell somebody you have to violate your faith as a condition of employment, that is harassment. And I'm trying to get the courts to recognize that that's not okay.
It's interesting, Alan, as you're talking about this, it clearly was a hot button topic. It still is. Many people feel strongly about the issue. One of the key legal problems of that time was that companies and employers were misconstruing what religious freedom was, and they were conflating it with institutional positions as opposed to personal positions, right?
In other words, if your church taught that the vaccine was okay, then you didn't have a right to differ from what your church taught. Yeah, no, that's certainly correct.
Yeah, yeah.
And that's not the law.
No.
But the other thing, this has all raised, and you and I heard some of this at the conference we attended recently. How do the courts understand and recognize religion that
Yes.
deserves protection, right? And what the courts are used to dealing with is reasoned arguments, okay? The Bible says not to work from sundown Friday to sundown Saturday. That's the fourth commandment. They can understand an argument like that. Or if someone says, I observe the Lord's Day because the Bible says something about the Lord's Day. Okay, it's a left brain, rational kind of argument or position that you can relate to intellectually. When somebody says, I chose faith in God rather than faith in government, courts don't know what to do with that. Now, one of my clients is a Hispanic immigrant who works in food service, very minimal education. And when I asked her why she didn't get the vaccine, it was very simple. I prayed about it, and God told me not to.
Hmm.
Now, I don't know how you gainsay that, but courts are not really receptive to those kinds of arguments because, in the words of Justice Scalia, who trashed religious freedom a generation ago in a case involving peyote use, drug use, he was afraid that then every conscience would become a law unto itself. That's his term. And, you know, I understand his concern, but I also understand the very simple faith of some of my clients.
But it goes to this central question, which has always existed in this area of jurisprudence, which is how do you determine, on what basis do you, how far can the government inquire into the sincerity or rationality of a belief before they allow religious freedom protection? Because religious freedom protection has to be limited some way. Otherwise, Scalia is absolutely spot on. We live in an anarchy where anyone can assert a conscience right and do whatever is right in their own eyes. So there must be some limiting principles that can be applied by courts.
So, Bettina, I don't know the answer to that question, but I will answer it this way. My staff and I screened literally hundreds of calls from people who wanted help getting, religious exemptions to the vaccine. And when we would discuss, well, how many of those had genuine religious objections? The answer from some was not many. Um, when we talked to people, we could tell if their objection was really religious or not. So practically, yeah, you can weed out the ones that are not religious if you know what you're doing. But look, when I was in law school, I clerked for a couple of law professors, and I read every law review article discussing the definition of religion. And I came away absolutely convinced that none of the definitions were adequate.
Right. Right.
And how do you protect religious freedom? You protect it broadly under the Free Exercise Clause, and you define it narrowly in terms of how you're going to separate church and state under the Establishment Clause. I came away with those basic concepts, but very, very difficult task to define religion.
It's impossible. I mean, because if you take a deist definition, then you're excluding some world religions, right? But then again, there has to be some difference between a religious belief and purely a philosophical or conscience-based belief, right?
Right. And actually those tests exist to, around the gray areas, there are legal tests to separate what's truly religious from what's not religious. The problem is the courts are trying to tell Christian people that they're exercising faith in God and not getting the vaccine was not a religious decision. It was really a decision based on secular considerations. And that's just judicial bias.
Interesting, Alan. We could have a very long discussion on this because it's an issue that deserves further attention. But you're identifying a critical issue going forward. How do courts and how will courts continue to define religion and religious beliefs, and how will they choose to protect them? So maybe we should have a part 2 on this, Alan.
Sure. And we'll see how the 60th anniversary goes. We've got an anniversary all year long, so we can keep celebrating.
We'll do it. So thanks for a great interview, Alan. This has been Just Liberty, where justice and liberty meet. I'm Bettina Krause with Alan Reinach, and until next time, remember, eternal vigilance is the price of liberty.